Tēnā koutou, kua hui hui mai nei. E maki ana o ki te kohanga nui tātai ture, hei kai whaka ako ture, ko Graham Austin, taku ingoa. Welcome everybody. My name is Graham Austin. I'm one of the academics here in the law faculty. I have the privilege of being on the organising committee for the Sir Ivor Richardson Lecture in Private Law, together with Justice Posh, Justice Palmer, Justice Collins, and Professor Darlin, who joins us from the University of Richmond and will be a full-time member of this faculty in January. Now, our speaker tonight, Professor David McLauchlan, requires absolutely no introduction to anybody in this room or to anyone in a room where smart lawyers gather. I will introduce him, nevertheless. I also say a few words about Sir Ivor Richardson, for whom this lecture is named. I'll say a bit about the lecture series and how things will run this evening. This year, there's only going to be one introduction, but you can probably tell I've got a lot to get through. So the Ivor Richardson Lecture is named for a giant in our jurisprudence, of course, and I want to acknowledge that at the outset. Second, I want to thank all of you for coming. That we are nearly oversubscribed says something about the mana of Sir Ivor, but also something about the esteem with which David is held. And of course, we also welcome David's family here tonight. Next, I want to acknowledge the financial support that we've received for this lecture from the Michael and Suzanne Boren Foundation. This is the second year that the Boren Foundation has supported this lecture. Thank you for that. And also, Sir Ivor was a partner in Watts and Patterson, a predecessor firm of Minter Ellison Rudd Watts. And so we're delighted to have the financial support of that firm tonight. I also want to thank the professional staff in the law faculty. They are the people who work very hard behind the scenes to make all of this happen. Now, the lecture is named for Sir Ivor to, as I say, mark his many contributions to our jurisprudence. He was a professor at this law school, then he was its dean, and later on he was chancellor of the university. He was appointed to the High Court, and very quickly after that, he was elevated to the Court of Appeal. He served as president of that court from 1996 to 2002. The many public honours that recognised Sir Ivor's distinguished contribution to New Zealand included his knighthood, the New Zealand Order of Merit, and this university awarded him an honorary doctorate in 1989. After his retirement, he was a distinguished fellow at this university, and he was in that building over there almost every day, participating in the intellectual life of the building. Unswervingly gracious, he always found time to talk with us about our research, especially the work of more junior colleagues. He sharpened our analyses and insights with his generous interventions in our work. We miss him greatly. Now, when introducing Professor David McLauchlan, I'm not going to repeat all the many achievements that we listed in the vitae that we distributed ahead of the time. His epic career, his many articles, his distinguished visiting positions at leading universities around the world. We know all of that. Instead, I'm going to tell you about something that happened a couple of months ago. It was the occasion of David's final lecture in contract law as a full-time member of the faculty. After the lecture, the students, his colleagues, and at least one judge formed a guard of honour across that courtyard and cheered David as he made his way up to the sound room for a farewell reception. The students thronged the sound room. It wasn't just the free food. The love and respect they have for David was palpable. I was asked to say a few words at that event. I pointed out that David is the last professor to retire who taught me, and I said that I was feeling vaguely orphaned by the experience. It occurred to me tonight that that's probably true of a lot of you as well. I tried to convey to the students something of the esteem with which David is held. Everything he writes about contract law, Supreme Courts around the world listen. He is, simply put, a giant in his field. There are a few things I didn't get a chance to say at that event, so you're captive here, so I'm going to say them now. Students sometimes feel that David can be, I don't know, a bit tough on them. He could also be a bit tough on his colleagues. And I've heard mutterings that he can be a bit tough on our judges. What I didn't have a chance to explore with the students was something about why. This lecture for Sir Ivor is in private law, contract, the area with which David is most renowned, tort, restitution, property, and so on. These are areas of law that individuals and firms rely on to support their private choices about how to organise their lives, not so much in their relationship with the state, but in their relationship with each other. And for those choices to be meaningful, we need sound and reliable doctrines and institutions that will deliver the dignity of participating in well-functioning markets. And we hope that the Ivor Richardson Lecture will be a forum in which we can explore how best that can be done. Now, when a leading professor such as David pays us the respect of demanding rigour, he's really asking us to bring our best selves to our work. Those New Zealanders who need the law to support their choices, their aspirations for a good and dignified life, are relying on us to do so. And David, in his work, his scholarship, his teaching, his public service, models what it means to step up to that challenge. Now, just one final thing about teaching. When I was living overseas and I would come back to see my mother and whānau and friends and so on, I'd often make a point of sitting in on one of David's lectures just to check in with myself about what really great law teaching looks like. In some years, I used to attend a contract lecture before seeing my mother. I couldn't tell her. But I always came away thinking, yes, that's how it's done. David's going to talk for about 45 minutes. There will be a chance for a few questions after that. And then Justice Koch will give a vote of thanks. I don't want to anticipate what Justice Koch will say. I wouldn't dare. But I am confident that we will get to the end of David's remarks thinking, yes, that's how it's done. Join me in welcoming Professor David McLauchlan to deliver the 2024 Lecture in Private Law.
Your Honours, colleagues, members of the profession, past and present students, friends and family. Seeing some members of my family here tonight reminds me of what an auntie said to me after my inaugural lecture over 40 years ago. She said, "I didn't understand a word you said, but it sounded good." Thank you, Grant, for your generous words. I appreciate them. It's my privilege and pleasure to deliver this lecture in memory of Ivor Richardson, who gave such outstanding service to our law and government, to the judiciary, to this university and this law faculty, as well as so many other areas of social policy and public administration. Ivor taught me tax law at both undergraduate and postgraduate level. In 1970, he was Dean of the Faculty of Law here, and along with another great lawyer, George Barton, he interviewed me for a junior lectureship position. Fortunately, the application was successful, and 54 years later, I'm still gainfully employed, albeit, as you've heard, not for too much longer. After his retirement from the bench, Ivor spent a good deal of time at the law school, and I and many of my colleagues enjoyed our dealings with him. Now, my thesis tonight is that when we ask the basic legal questions, is there a contract? And if so, what does it mean? Essentially, the same principles apply in New Zealand as a result of the Supreme Court's decision in Bathurst Resources. This represents a departure from the law in other common law jurisdictions, notably the UK and Australia. But I'm going to argue that this development is to be welcomed because it improves the transparency and coherence of our law of contract and brings that law into line with the best international practice. Now, I want to start in a slightly tedious way by highlighting two of the most troublesome terms in the law of contract. These are subjective intention and objective intention. We're routinely told by judges who are faced with issues concerning the formation or interpretation of contracts that their task is to determine the parties' objective intention, not their subjective intention. It's said that evidence of subjective intention is irrelevant and inadmissible, and such evidence is often understood to include anything that points to the party's actual intention. Now, some of you may know I have been arguing for years that this is an oversimplification. Of course, no one has ever suggested that a court should be able to inquire into the parties' states of mind and hence allow them to testify as to what they each intended at the time of the alleged contract. However, I argue the situation is entirely different where there is reliable evidence of communications between the parties showing that they reached an agreement that was intended to be binding, or, as the case may be, they formed a common understanding as to the meaning of language in dispute. What I'm saying is that too often the dirty words subjective intention are used to rule out any evidence pointing to the parties' actual mutual intention, on the basis that the sole task of the court is to determine their objective intention, commonly also referred to as their presumed intention. In fact, accepting and giving effect to evidence of the kind I have mentioned is not in any way inconsistent with an objective approach. One is still ascertaining the parties' intentions through objective evidence. Now, I have read judgments that in effect say to the parties, don't you tell me what you intended. It's my job to decide what you intended. I also recall one New Zealand case that included a finding by a High Court judge that the parties actually intended to be bound by an informal commercial property agreement. He said that their actual belief at the time was that a binding deal had been concluded. Anything that remained was mere drafting detail. However, he then concluded that that's irrelevant. The question of intention to be bound was not to be approached subjectively. It was to be approached on an objective basis. The test was whether a reasonable person would have inferred that the parties intended to be bound. And I've called this objectivity gone mad. How reasonable persons would have understood the transaction was irrelevant in this case. While the presence of actual consensus and intention to be bound is not necessary for formation of a binding contract, surely it is sufficient. Now, difficulties also arise in relation to the term objective intention. It's routinely said that it's a basic principle that the law is only concerned with the intention of the parties as objectively ascertained. So, in an interpretation dispute, the judge must try to ascertain what a reasonable person would have understood the parties to have meant. But who is this reasonable person, and what does he or she know about the background to the contract and the parties' dealings? It's widely thought that the common law depersonalises the contracting parties and asks what a detached or outside observer, the reasonable fly on the wall, would have taken their intention to be. Now, on one view, this objective observer possesses business common sense and has knowledge of all the terms of the contract and the surrounding circumstances, but apparently he or she is unaware of or wholly unconcerned with their actual intention, even if it is shared and manifested in communications between them. Nevertheless, it is almost equally common to refer to the objective test as requiring a determination of what a reasonable person in the position of the parties or in the position of the promisee would have inferred. Now, on this version of objectivity, a reasonable person who's asked to determine what the parties appeared to mean by particular language would surely give decisive weight to communications between them, establishing either a shared actual understanding of the meaning of the language or an understanding of one party where that party was led reasonably to believe that its understanding was also shared by the other party. In this context, there is no sensible distinction between meaning and what the parties meant, because what the parties meant is the meaning. The contract textbooks don't say that, but I'm telling you now. What the parties meant is the meaning. Similarly, a reasonable person who's asked to determine whether the parties intended to be bound would give decisive weight to communications between them, establishing either a shared actual intention to be bound or the intention of one party where that party was led reasonably to believe that its intention was also shared by the other party. Now, you've seen I've handed out a document, not because I want to ask questions about it. You can all sit and relax. A document that looks like an obvious binding contract. Sam Sellers and Betty Byers have signed an unambiguous and unconditional agreement for the sale of land. But it may not be binding. What if there is convincing evidence that prior to signing the agreement, the parties orally agreed that it was subject to Betty obtaining finance of, say, $200,000? Now, I'm sure that many lawyers would be startled to learn that there's a well-established line of case authority to support the view that evidence is admissible to show that the agreement was executed subject to a condition precedent. I listed the cases here, but you no need to note them at all or remember them. That's just to verify what I am saying. Now, it's equally clear that evidence is admissible to show that the document was not intended by the parties to create the legal rights and obligations it appeared to create, and therefore it was a sham. Perhaps Sam prevailed on his friend Betty to help him delay a potential mortgagee sale of the land. Okay, it was trickery, but it might have been a sham. Well, some more examples. What if Betty did not actually intend to be bound because she thought that there would be no binding commitments until her lawyer had approved the agreement or until she'd paid the deposit? That's actually not an uncommon thought. Is she nevertheless bound? The answer is probably yes. It suffices that Sam was led reasonably to believe that she intended to be bound. This is the objective principle. Now, as Justice Blackburn said in the famous case of Smith and Hughes, if whatever a man's real intention may be, he so conducts himself that a reasonable man would have believed that he was assenting to the terms proposed by the other party, and that other party upon that belief enters into the contract with him, then the man thus conducting himself would be equally bound as if he had intended to agree to the other party's terms. In the 1870s, they didn't believe in gender-neutral language. I was thinking of changing it, but then thought you should have the real thing. Now, as that statement makes clear, the objective principle involves a subjective element. The party's actual intentions and beliefs are relevant. The principle requires not only that a reasonable person would believe that Betty intended to be bound in my last example, but also that the other party upon that belief enters into the contract with him. So Sam cannot reasonably believe that Betty intended to be bound if he knows otherwise, or indeed ought to know otherwise. The position is the same if it's established that he shared Betty's intention at the time of the alleged contract. However, I hasten to add that in the absence of any such evidence, a court will assume and is entitled to assume that Sam's actual understanding corresponded with the way in which a reasonable person in his position would have understood it. Well, let's assume now that there's no issue concerning lack of intention to be bound. Instead, one party is arguing that not all the terms recorded in that document I've given to you were agreed to. Suppose that the parties were preparing for settlement of the transaction when Sam realises that the price stated in the document is $400,000 total, not $400,000 per lot. Oh no! He says out loud with a few other words. He says, and let's assume a court will believe him, that he always intended to sell both lots for the total price of $800,000. What is the legal position? There are three possible legal conclusions here at common law. First, the written agreement stands. Second, there's no contract. And third, there's a contract at $800,000. How can this be? Well, let's look at the first possibility. The written agreement stands. That is, there is a contract in accordance with the written terms, and Sam is bound to sell at the stated price of $400,000. There will be such a contract if Betty intended to buy at that price, and if Sam led her reasonably to believe that he intended to sell at that price. And obviously, the fact that the written agreement plainly provides for a sale at that price will be a strong factor supporting this conclusion. But it can't be conclusive because, contrary to a widespread assumption among lawyers and judges alike, I have to say, a written document that looks like a binding contract is not necessarily a contract at all. Such a document, of course, normally takes effect as a contract, but this is because the objective principle is or will be satisfied, not simply because it contains promises verified by a signature. In other words, the promisee will normally have been led reasonably to believe that the promisor accepts and intends to be bound by the terms of the document. Well, that brings me to the second possibility. There's no contract, just a piece of paper. You could just rip up that thing in front of you because it's nothing. It's not a contract at all. Sam may be able to convince the court that Betty knew that he didn't intend to sell at the stated price. She cannot reasonably have believed that Sam intended to sell at that price if she knew otherwise. And the position is the same if Betty ought to have known of Sam's true intention. By definition, she cannot reasonably have believed that he intended to sell the land for $400,000 if she ought to have known otherwise. That's actually contentious, but to me it's common sense. But the late Professor Brian Coote from Auckland and I have disagreed on this point. I believe I'm right. As I always do. We will assume here that although Betty knew or ought to have known of Sam's understanding, she had not actually led Sam reasonably to believe that his understanding was accepted. Now, if she had done that, if she not only knew what he intended, but led him to believe that his understanding was being accepted, then the third of my possibilities arises: a contract in accordance with Sam's understanding. In other words, there's a contract at $800,000. There are two main reasons for this third conclusion. The court may be convinced that the actual intention of the parties was the same: a sale at a price of $400,000 per lot. For example, evidence of the parties' negotiations may establish that they were always haggling over a price in the vicinity of $400,000 per lot. And hence the court is satisfied that the omission of the words per lot was inadvertent. This will be an obvious case for the equitable remedy of rectification on the ground that there was a common mistake. One of those jurisdictions too many lawyers forget: rectification. If the contract doesn't reflect the intention of the parties, seek rectification. Now, an alternative basis for finding a contract in accordance with Sam's understanding is that although Betty did not share that understanding, she led Sam reasonably to believe that she was intending to buy the land at the price of $400,000 per lot. Perhaps all of the discussions prior to signing the written agreement were in terms of a price per lot. And Betty, noticing the mistake, sought to take advantage. Now, this would be a clear case for rectification on the ground of known unilateral mistake. Here, rectification is required not to punish Betty because she was very naughty, to take advantage of the known mistake, but to give effect to the true bargain as objectively ascertained. The law in this area is murkier than it should be. And none other than Lord Hoffman has referred to one of my pieces in this area as heretical. And one of my best friends in a leading firm in London told me, in jest of course, that burning at the stake was too good for me. Well, again, I still believe I'm right. Now, in all the examples I've given so far, all relevant evidence is admissible. This includes evidence of the parties' prior negotiations and subsequent conduct, because it may assist in establishing either party's contention. Furthermore, all the answers I've given are applications of the Smith and Hughes version of the objective principle. And that principle, that version of it, undoubtedly represents New Zealand law because it has been accepted by our courts on numerous occasions. But unfortunately, our neighbours across the Tasman typically take a different view. The leading case is Taylor and Johnson. The facts were simple. Mrs. Johnson signed a written agreement to sell 10 acres of land to Mr. Taylor at a price of $15,000. She actually intended to sell for $15,000 per acre. And Mr. Taylor knew this. It was held that a contract was formed, albeit one that was voidable, capable of being set aside in equity because Mr. Taylor was naughty. Not only did he know of the mistake, he deliberately set out to ensure that Mrs. Johnson did not discover it. And the judges subscribed to the extreme form of objective theory that I mentioned earlier, which I said is commonly referred to as detached objectivity, under which a contract is formed when to all outward appearances the parties are agreed on the same terms and on the same subject matter, regardless of actual intention and the state of knowledge of either party. And what the High Court did in this case was to endorse what I have to say is the heretical view of none other than Lord Denning. And his view was, once the parties, whatever their innermost states of mind, have to all outward appearances agreed with sufficient certainty in the same terms and on the same subject matter, then the contract is good until it is set aside for some valid legal reason. Neither party can rely on his own mistake to say it was a nullity from the beginning, no matter that it was a mistake which to his mind was fundamental, and no matter, and there's the nub, no matter that the other party knew that he was under a mistake. That's not the law in New Zealand. It can't be, given the number of times we've endorsed the objective principle in Smith and Hughes. Now, astonishing, and Justice Blackburn's version of the objective principle in that case was viewed by the High Court of Australia as representing a subjective theory of contract formation. I thought to myself when I read it, what? A subjective theory of contract formation. Presumably, it was thought so because it holds, that is, the Smith and Hughes principle holds, that there cannot be a contract when the promisee knows, that is, the plaintiff or promisee knows or ought to know that the promisor does not intend to contract on the stated terms. However, that's wrong. The fact that the promisee's state of mind is taken into account does not mean that Justice Blackburn was applying a subjective theory. A subjective theory would inquire into what the promisor, Mrs. Johnson, intended, whereas an objective approach asks what a reasonable person in the position of the promisee, the defendant, Mr. Taylor, would believe the promisor intended. And a reasonable person who knew that she did not intend to be bound to a particular term would not treat the promisor as having agreed to that term. Well, what would be the legal position if the facts of Taylor and Johnson arose in New Zealand today? There is one big giant elephant in the room that I will ignore because it would unduly lengthen this lecture. And we don't want to do that. It concerns some vexed and unresolved questions about the application of our contractual mistakes legislation. And it would take me another hour to explain why this area is so difficult. The key point for tonight's purposes is that in Taylor and Johnson, there's prima facie no contract at common law. since Mr. Taylor did not satisfy the objective principle in Smith and Hughes. Another possibility is that Mrs. Johnson might actually, and the High Court did raise this, might actually seek to have a contract enforced against Mr. Taylor in accordance with her understanding. 15,000 per acre. And she could do so by seeking what I referred to earlier as the equitable remedy of rectification. For this purpose, I want to emphasise that it wouldn't suffice that he was aware of the understanding. She would have to establish that he led her reasonably to believe that he accepted her understanding. Okay. Given that the objective principle as formulated in Smith and Hughes is a, if not the, core principle of the common law of contract, the next question that arises is, does it also apply when the issue concerns the interpretation of an admitted or assumed contract? To what extent do the actual intentions of the parties, their knowledge and beliefs, inform the meaning of a contract? Suppose there is convincing evidence of communications between the parties, pointing to a conclusion that they shared a particular meaning of the words in dispute at the time of the contract. Or there is evidence of the meaning intended by one party and that this party was led reasonably to believe that the other party accepted her meaning. Well, historically, all common law courts drew a sharp line between the principles governing formation of contracts and those governing their interpretation. It was said that the task of a court when interpreting a contract was to determine the presumed intention of the parties, so that, for example, evidence of their actually intended meaning derived from their prior negotiations and their subsequent conduct was inadmissible. So, in the first three editions of Sir Kim Lewison's practitioner textbook on interpretation, the author said that once it has been established that a contract has been formed, the actual intentions of the parties as to the meaning or effect of the contract become irrelevant. Interestingly, this statement has been omitted from later editions, perhaps in response to the mounting number of exceptions that I and other commentators have pointed to. But the author's sentiment still commands support from leading courts and judges. The High Court of Australia, for example, perhaps not surprisingly, has been unwilling to loosen the shackles created by Sir Anthony Mason's observation in the Cadelpha case, where he said, great judge, Sir Anthony Mason, I had the pleasure of discussing some of these issues with him. He actually admitted he might have gone too far, but you're not allowed to tell anybody. He said that evidence of the actual intentions, aspirations, or expectations of the parties before or at the time of the contract is inadmissible, because the court's task is to determine the presumed intention of the parties. Now, more recently, Justice Leggett, now Lord Leggett of the UK Supreme Court, highlighted two distinctive features of the rules of English law governing the interpretation of contracts, namely the irrelevance of the party's actual intention and the inadmissibility of evidence of their prior negotiations. We can imagine that raised my hackles. And I've taken issue with Lord Leggett, Justice Leggett as he then was, in response to one of his articles in the Law Quarterly Review. What his lordship said was what the parties to the contract actually meant, or whether they had any pertinent subjective intention at all, is irrelevant to the task of interpretation. Rather, the court identifies the meaning of the language used by assuming that the parties were reasonable people, using the language of the contract to express a common intention. Well, as already indicated, I've long thought that that view is wrong. There's no sensible reason why the interpretation process required to determine whether a contract was formed should differ so fundamentally from the process required to determine the meaning of that contract. The strict objective approach, which seeks to discover the presumed intention, is fair enough, as more often than not happens, the parties didn't anticipate or contemplate the situation that has arisen. But to my mind, it's entirely another matter to elevate it to a universal rule and to reject out of hand what may be relevant and reliable evidence from the negotiations of the meaning they actually attributed to the words of the contract. Such evidence should be equally as relevant as evidence of their actual intention to be bound. And I have an ally in this in the early days in Justice Ted Thomas, who once said in typically forthright fashion in the Gibbons Holding case, the notion that an intention can be imposed on the parties contrary to their actual intention is repugnant to any concept of fairness, common sense, and the reasonable expectations of honest men and women. It should be repugnant to the common law. Ted Thomas and I get on quite well. Well, we used to when we last spoke. Now, I've long thought that that view is just, this view that the party's actual intention is irrelevant is just wrong. It's particularly so when it's considered that disputes over the meaning of contractual language will very often call into question whether the misunderstanding between the parties meant that no binding contract was formed in the first place. So an issue of interpretation may call into question whether a binding contract was formed in the first place. Take, for example, the facts of a celebrated American case, Fragillimont Importing, decided by a very famous judge, Justice Friendly. What a great name for a judge. When are we going to have Justice Kindly or Justice Pleasant or Justice Caring? Anyway, Justice Friendly began his judgment famously by asking, what is chicken? What is chicken? The plaintiff company had entered into a written agreement with the defendant for the purchase of a large quantity of chicken, meeting certain detailed specifications as to weight, packaging, and so on. The shipment met those specifications, but the plaintiff rejected it on the ground that it was stewing chicken. Didn't want stewing chicken. And it certainly wasn't the sort of chicken that Colonel Sanders would want for his KFC outlets. Incidentally, I read the other day that the Colonel and his wife lived well into their 90s. So perhaps Kentucky Fried Chicken is good for us. Returning to the case, however, the plaintiff sued for damages, arguing that the word chicken meant young birds, suitable for frying, as opposed to fowl, F-O-W-L, which were more mature birds, suitable only for stewing. The action failed, however, because the plaintiff company had not satisfied the burden of showing that chicken was used in the narrower sense claimed. If the parties had been reversed and the seller had been suing for damages or claiming the purchase price, it seems likely that this action would also have failed due to the seller's inability to prove that chicken would have been used or was used in the broader sense. as including the mature birds. Essentially, although the case was treated as one of interpretation, there was no contract formed, since both understandings were equally reasonable. Well, thankfully, one of the effects of our Supreme Court's decision in Bathurst, just I'll remind you of the citation again, one of the effects is that there's no longer a sharp divide in New Zealand law between the principles of contract formation and the principles of contract interpretation. In essence, the Smith and Hughes principle now pervades both areas. The Supreme Court rightly accepted that evidence of uncommunicated subjective intent is irrelevant under the objective approach. But what it ruled most importantly is that the promotion of commercial certainty should not be allowed to defeat what the parties actually meant by the words in which they recorded their agreement. The judges were clearly of the view that the objective test requires a determination of what the reasonable person in the position of the parties would have inferred, and that such a person would ordinarily give decisive weight to communications between the parties, establishing what I said earlier, that is, either a shared actual understanding of the meaning of the language, or the understanding of one party where that party was led reasonably to believe that its understanding was also shared by the other party. As a result, relevant evidence of the parties' prior negotiations and subsequent conduct must be able to be taken into account. Now, in so ruling, the Supreme Court endorsed the private dictionary principle, the so-called private dictionary principle, adopted in a much discussed case called the Karen-Altman for short, 1976 decision of Justice Carr, a well-known commercial judge. Now, the case concerned the meaning of the word after, an ambiguous word that can mean on the expiry of or at any time after. The intended meaning, the judge said, depends on the context. For instance, if we embark on a 20k hike through the forest and agree to stop for nibbles after 10k's, we mean that we will stop on the expiry of 10k's of walking and not at any time between 10 and 20k's. On the other hand, if an employment contract entitles the employee to retire on full pension after 15 years service, it's likely that this means at any time after 15 years, so that she can still exercise the option, say, when she has served 25 years. Well, coming back to the facts of Karen-Altman, that was a case in which it was clear from the parties' negotiations that the word after, in a term giving the charter of a ship the right to terminate the charter after 12 months trading, was being used in the sense of on the expiry of 12 months trading, not in the other possible sense of at any time after the vessel was traded for 12 months. So it was held that the charterer was not entitled to terminate the charter 17 months into the 24-month term. And so the charterer would have had to pay some whopping damages due to that, and the charterer had wanted to cancel because of a fall in the freight market. Now, the later view of the House of Lords, however, in the Chartbrook case is that, and I've got that on the screen here, is that the private dictionary principle adopted by the judge constituted an illegitimate exception to the rule excluding prior negotiations. That has been expressly rejected by our Supreme Court. Not often do we get our Supreme Court quite overtly disagreeing in this case, quite rightly, with the UK House of Lords, now, of course, the UK Supreme Court. So the British illegitimate exception is now the law in New Zealand. How about that? You didn't all know that, did you? Now, the Supreme Court was a little bit more guarded concerning the admissibility of evidence of subsequent conduct, because it stressed that care will need to be taken to assess the probative value of such evidence, and that it will not often be relevant. And I agree with that. The main impact of subsequent conduct evidence is that it may assist in the task of proving an agreed meaning. The fact that the parties have acted consistently with a particular interpretation, or that at least the party now denying that interpretation has so acted, may sometimes provide a reliable basis for an inference that at the time of the contract, they attached a meaning to the words in question, or that one of them attached that meaning and was led reasonably to believe that the other did so too. However, the conduct will rarely, if ever, be conclusive by itself. The party who denies the interpretation that the conduct allegedly supports will often be able to argue that the conduct has limited probative value because it's too equivocal, being consistent with a mistaken interpretation, or the granting of an indulgence. Nevertheless, when taken in conjunction with other evidence of the party's intention, found, say, in the prior negotiations, the subsequent conduct may sometimes tip the balance in favour of a conclusion that a particular meaning was indeed adopted at the time of the contract. Now, this is anathema, you can imagine, to the Aussies, when you have judges saying in the Supreme Court of Victoria, a mince pie doesn't become an apple tart because it's served for dessert. Well, when I respond by saying, well, it wasn't a mince pie at the outset. Now, a good illustration of this, as well as the significance of the changes in the law brought about by Bathurst, is provided by the judgment of the Court of Appeal, delivered appropriately for tonight's purposes by none other than Ivor Richardson, 33 years ago, in the case of Edwards and O'Connor. This was a remarkable case because, no doubt due to the apparently settled state of the law at the time, Ivor did not countenance basing the court's ultimately correct conclusion, I emphasise the court reached the correct decision, on the proven actual mutual intention of the parties, let alone having regard to subsequent conduct that strongly confirmed the existence of that intention. The facts in brief were these. The defendant entered into a written contract for the sale of her fishing business to the plaintiffs. And the plaintiffs alleged that it was orally agreed that if fishing quota were eventually allocated to the defendant under the new fisheries management regime, it would pass to them. The valuable fishing quota would pass to them. In particular, it was agreed prior to signing the written contract that the terms in that contract, fishing licence and goodwill, included the quota. The trial judge accepted this version of what had happened. He also relied on the defendant's subsequent conduct, which clearly demonstrated her understanding that the quota was to be transferred. The defendant had said, hurry up and pay the balance of the price you're getting that quota cheap. It was an admission of what the intention was. Pretty straightforward case. So, on the basis of these findings of fact, an easy case. The evidence of the prior negotiations, coupled with the subsequent conduct, combined to establish beyond any question that the actual mutual intention of the parties at the time of the contract was that fishing licence and goodwill included the quota. However, Sir Ivor, delivering the judgment of the Court of Appeal, although finding for the plaintiffs, did not regard the case as nearly so straightforward. And understandably so in light of the state of the law at the time. An easy case from modern eyes was made much more complicated than it need have been. It was decided at a time when it was accepted that the task of the court, let me repeat, was to determine the parties' presumed intention, and it was thought that evidence of negotiations or other manifestations of the parties' actual intention was not admissible as an aid to interpretation. Indeed, Ivor said that in his judgment. The plaintiff's claim to the allocated quota only succeeded because the court was prepared to hold that a reasonable person with knowledge of the factual background and the aim of the transaction would infer that quota was covered. Now, the position in New Zealand now is that a court would not have to look for a presumed intention when their actual intention that quota was to pass is established. Our law of contract is no longer quite so silly as it used to be. The telling admissions and the subsequent conduct, which understandably, given the state of the law at the time, did not rate a mention in Ivor's judgment, would now be entitled to considerable weight as verifying that the parties did actually intend that the quota was to pass to the plaintiffs. Now, of course, if the evidence of the subsequent conduct had stood alone, there was nothing in the prior negotiations, and there was nothing in the prior negotiations to support a finding that the matter had been addressed and agreed. The evidence would have carried much less weight. The defendant would have been in a stronger position to explain the conduct away. Well, I want to conclude with some brief observations about the important changes over the past 30 years in the basic aspects of contract that I've been talking about. I want to start by mentioning that there's no longer a plain meaning rule that previously required a finding of ambiguity before a court could have regard to any extrinsic evidence at all. As recently as 1993, the plain meaning rule was the basis of the largest ever award of damages in a New Zealand contract case at that time, some $73 million. That was the case of Benjamin Development and Robert Jones, where Sir Robert Jones was ordered to pay $73 million. Whether he did in the end is another matter, because the case was settled before going off to the Privy Council. Now, that case, I think rather astonishingly, has not rated a mention in the numerous subsequent cases that have adopted Lord Hoffman's restatement of the fundamental principles of interpretation in the investors' compensation case in 1998. Under those principles, the task of the court is to ascertain the meaning that a reasonable person with knowledge of the background would give to the contract. And the fact that the disputed words have an ordinary or conventional meaning is not conclusive. Indeed, it was accepted that, and still is accepted, that just as can happen with any serious utterance in ordinary life, sometimes people can convey their meaning unambiguously, even though they use the wrong words. So we have no real difficulty in understanding what the British Home Secretary meant when he said in Parliament, "We must eliminate the homeless." We make the mental adjustment. He didn't mean that we've got to exterminate them. He used the wrong words, but there's no ambiguity there, according to Lord Hoffman's principles. Now, the main point here is that the decision in Bathurst has liberalised the law even further, with the consequence, which is my thesis tonight, that there's no longer an artificial divide between the principles of contract interpretation and contract formation. Not only is our law of contract interpretation much more coherent and transparent than it used to be, but it now almost exactly replicates the best international practice, as reflected in Chapter 4 of the UNIDROIT Principles of International Commercial Contracts and Chapter 5 of the Principles of European Contract Law. In this area, we're much the same as the international instruments and indeed as German law, French law provide. In this respect, I agree again with Justice Ted Thomas's observation in the Drew Holdings case. It is clearly desirable that the approach of the courts in this country to the interpretation of contracts coincides as far as possible with international practice. Now, I should also mention that the UN Sales Convention, a convention that has been part of our domestic law since October 1995, expressly provides that evidence of the parties' negotiations and subsequent conduct is admissible as an aid to interpretation. So wouldn't it be odd if such evidence were admissible when interpreting international sales contracts, but not other commercial contracts, or indeed contracts generally? I think that supports the approach that the Supreme Court has taken in Bathurst. Nevertheless, I'm conscious that the developments I have described, particularly the reforms in Bathurst, will by no means have pleased everyone in the profession, and certainly not everyone here tonight. Foremost among the concerns is that admitting evidence of prior negotiations and subsequent conduct will increase the time and cost involved in civil trials. Why? Well, where there's a large amount of money at stake, as often happens in interpretation cases, judges will perhaps be inundated with large bundles or even trolley loads of documents that have dubious relevance. Well, to my mind, the answer to this concern lies in appropriate case management and judicial warnings of adverse costs orders if large amounts of irrelevant material is introduced. In any event, even if you are sympathetic to that objection, I have highlighted elsewhere 5 exceptions to the old law, 5 exceptions to the old exclusionary rules that enable the judges, even in Australia, to give a meaning to contractual terms that is consistent with the actual mutual intention of the parties. So, my argument has been that the Bathurst rulings will not have the effect of increasing the length and cost of civil trials. And I prefer the greater coherence and transparency of the new law. Indeed, a case like Edwards and O'Connor might well be settled in favour of the plaintiffs before a court hearing. Now, another objection is that there will now be greater uncertainty in the outcome of contract litigation. Well, I'm one who believes that the opposite will be the case, where the evidence reveals that the parties formed a common understanding or a common intention as to the meaning of the words in dispute. Because the litigants will be aware that they cannot use technicalities to hide behind the truth or to hide the truth. I will leave the final word to a great judge who's sympathetic with the views of myself, and even he cited me a few times, which was nice of him, and Ted Thomas, who was a friend of Lord Nichols. Lord Nichols of Birkenhead. He wrote extrajudicially. That means he wrote in a law review article called "My Kingdom for a Horse." Great title for an article. the meaning of words. He said, where the pre-contract negotiations furnish a clear insight into the intended meaning of the disputed provision, admission of that evidence can hardly promote uncertainty. Rather, the reverse. It is the exclusion of that evidence which generates uncertainty by enabling one party to contend for a meaning he knows was not intended. Since the extrinsic evidence is not admissible, he's able to advance a case which otherwise would be untenable. Thank you all for coming.
Now, there's time for a couple of questions. People in the audience who are pleased or displeased with what David has said tonight. So, floor's open. Nicole.
See what students like.
But I don't lecture so much.
I was interested in how often you said that when these very formalistic views were adopted, or the objective approach that you don't like was adopted, how often you said that there was an alternative way of getting to what you regard as the right outcome, often through the availability of equity. So in a case like Taylor and Johnson, the Australia could avoid the unfair result by resorting to equity. I'm just wondering how much of the role you think equity and the availability of those alternative ways of solving the problem like rectification have played in the development of that more extreme construction in the first place of the contract, but the fact we had to get out of jail free.
Yeah, I think in a case like Taylor and Johnson, there were the special facts of the misbehaviour, not just the mere knowledge of the mistake, but the fact that Mr. Taylor set about to ensure that Mrs. Johnson didn't become aware of what the contract actually said. And so, yes, the court got there, got to the right conclusion in that case by using a principle that you could set aside a contract on the basis of known unilateral mistake with this element of unconscionable behaviour. Now, there is also the importance of the equitable development or equitable jurisdiction to rectify a contract, which is often said. And indeed, in my private dictionary case, Lord Hoffman said, that's a case for rectification. The parties made a mistake. But I don't think that can be right because the parties used the words after in one of its permissible senses. They didn't make a mistake at all. Now, Lord Hoffman, apart from disagreeing with the result, also went on to say the Stockholm Convention could apply. Well, this makes the law not very transparent at all. There's too many damn Stockholms out there. And you're stopped from denying the meaning that the parties actually agree. It says, well, why not just say it is the meaning? Equity has had a limited role. It can be an important role, and certainly the likes of Lord Hoffman saw rectification as a basis for dealing with the private issue cases. But of course, my argument is that law is now more coherent and more transparent. That's the result of what the Supreme Court has been saying. Making points that I've been for many years, not that they necessarily agree with
There's a question there. Can I get you to introduce yourself? Just
My name is Barry Brown. I'm recently retired after 50 years as a corporate lawyer. I've spent a lot of my life drafting contracts involving huge sums of money for various parties, and I've litigated what the effect of a comma is in a charter party. But from my perspective, the words mean what they say. And if there's the way that I've always operated, and I find it difficult to accept any other proposition, is that if there is a clear meaning on the face of the contract from the words, then game, set and match. It's whatever the judge adopting a common sense approach to the words used and the context in which they're used decides. So if I was ever on the Supreme Court, and I think I'm not going to be, and maybe there's a reason why I never was, but I would say let the words speak. Here we are. Indeed, I was at Victoria University from 1969 to 1972. Yeah. Indeed, we did. Yep.
I say to you that normally that is the case. It will be a strong case if you're going to depart from what you say is the clear language of the parties. But it's not the law anymore. It's not the law. Now, I'm not defending all aspects of it. But our Supreme Court, every epiphany of the Supreme Court has said, Justice Arnold has said, here it is, blame him. As had been laid down earlier, there is no need for an ambiguity before one considers evidence of extrinsic material that might tend to show that a different meaning was intended. Now, you remember that term, so I do read what you say. So, my response is I understand, and there are many practitioners coming from where you are, and this is a time-honoured attitude. That's the attitude of the lawyer who believes that they can find meaning by putting their feet up on the desk, reading the document and solemnly pronouncing what it means. Can't do that nowadays. Normally they'll be okay. Normally they're okay, and it will be only the exceptional case where you will be able to bring in, like the Karen Altman, even in the Bathurst case itself. Talking about, you said about the judges adopting common sense techniques, or adopting a common sense approach and giving effect to the plain meaning. The fact of the matter is that judges disagree over what the plain meaning is. There have been cases, there was cases that went to the Privy Council in the mid-90s, in which the Privy Council found plain meanings contrary to the plain meaning that our Court of Appeal had found. And as I pointed to cases also where judges disagree over what's common sense. Only lawyers will disagree over what is common sense. This regularly happens. So I'm sympathetic to the starting point, as I said, it isn't the law. And I don't think, I mean, you'd be able to decide to look at it. Let's just read the document. Decide what a reasonable person would do. To me, that's counterintuitive. I think the Supreme Court about this saw that.
I think we've got time for one more question here, and then we'll turn to Justice Coach to get his vote of thanks.
Hello, Professor McLauchlan. I think this is the first time I've actually volunteered to ask a question in class, but
Tried asking you questions many years ago.
but I don't for cover, left, right and centre. My name is Sean Rush. I'm a commercial barrister here in Wellington, former city councillor. Yeah, I knew that was going to come out. And I finished up in 1991 at Vic, but was back this year doing a course, some sympathy with what Barry's got to say. 25 years of or 30 years of drafting contracts, trying to get it just right. And what I'm hearing is that actually it's not so important that you do. But I do wonder whether, the way that we negotiate these days and practice law these days are very different to what we used to do. And I do wonder whether the use of email, for example, and the paper trail and the way that people have, you can evidence things much more easily than you used to. And I wondered whether that was one of the reasons that's giving momentum to what the Supreme Court are now saying.
Well, the matter is, all cases they're usually the exceptional cases. Most often, the contentious cases or not so contentious cases are settled. But they're not as well drafted as you used to draft them. Okay? And sometimes they're very sloppily drafted. There's inconsistencies. And that's what happened in the investors' compensation case itself. But what the courts have said is that we will not allow the interpretation, plain meaning of the words to achieve a result that's unreasonable or clearly contrary to the party's intention. The House of Lords held in 1976 that 13 January meant 12 January. How about that? 13 January. Your birthday meant 12 January. But yes, that's what the House of Lords held. Why? Because a reasonable person with knowledge of the background would have understood that in giving notice to terminate a lease, the lessee meant 12 January, not 13 January, and had made a mistake. And that a reasonable person in the position of the landlord or lessor would not have seen any problem. They would have understood exactly what was meant. Now, arguably, I've argued this too, and so have other writers, that actually 12 January was the right date to put, because there was a right to terminate a contract on the third anniversary. And on, the word on may well have been used in the sense of after. Did you know that the word on, O-N, is one of the most ambiguous words in the English language? It can mean before, during, or after. And arguably, when the lessee in that case I mentioned, that's Manai Investment, in the appeal cases, I haven't made it up. Arguably, on 12 January was meant as meaning after. Because otherwise, the lessee would have to have got out a day before the lease actually determined. But none of one of the great modern judges said, no, the notice of termination of the lease was invalid because had the wrong words had been used. But Lord Hoffman, who applied his so-called objective approach to come to a different conclusion, say that we can correct a mistake. Everyone understands what Mrs. Malaprop means when she says, you're as obstinate as an allegory on the banks of the Nile. In fact, Mrs. Malaprop made a zoological mistake as well because it's a crocodile. I think we used to laugh about that in the old 18th century days, listening to Richard Sheridan's play, The Rivals.
I have a feeling that this discussion is going to carry on at the reception afterwards, but now it's time to welcome Justice Koch to give it the vote of thanks.
Well, tēnā koutou katoa. This is likely Professor McLauchlan's last public lecture, and so I hope that you will forgive me if I think it's more important tonight to focus on him than on the content of the lecture he's just delivered. Professor McLauchlan is a remarkable professor of the law of contract, torts, commercial law and remedies, and it is a real matter of celebration that the Victoria Law School has held this outstanding scholar and teacher close for 54 years. His students now number in excess of 15,000 across 3 generations. They include fully 20 of the current Supreme Court, Court of Appeal and High Court judges, including me in 1977. Several cabinet ministers, including Chris Finlayson, KC, Chris Bishop and Simon Power. Several solicitors general, not quite managing to reach back by the John McGrath or Terence Arnold. And many other notables. David is renowned for his teaching. On his office door is penned what has become his motto from Harold Berman, that renowned law professor at Harvard and Emory. It reads, if a scholar is not a teacher, his scholarship will be sterile. If a teacher is not a scholar, his teaching will be superficial. He could have been, but is not, a Professor Kingsfield, terrorising his contract students into submission to learning, with all the warmth of a small perambulating iceberg. On the contrary, David is a deeply warm individual and his students utterly adore him. As Amelia Keane and Sarah Leslie noted in their introduction to the 2011 edition of the Victoria University Law Review, 2011, 13 years ago, celebrating David's 40th anniversary of teaching at this university, they said Professor McLauchlan lights fires of rebellion in many law students each year. He teaches respect for the law, not necessarily judges. He teaches his students to think for themselves. Actually, the passage went on to say something about taking judges' pronouncements with a grain of salt, but I've decided to omit that bit. So, except I think the omission didn't quite work. Turning to a scholarship, I doubt that any contemporary has garnered greater citation in the courts of Aotearoa, Australia and England. And with that comes a certain level of access. In the same Vic Law Review edition, Amelia and Sarah describe a contract class. Having completed a thorough study of the principles in ICS and impressed us with the correct spelling of Lord Hoffman's name, 2 F's, 2 N's, David turned to his lordship's comment that evidence of prior negotiations was inadmissible. He argued that that view was incompatible with the ICS principles and said that he had written to Lord Hoffman, enclosing a relevant article to tell him so. The class tittered appreciatively, but David was not finished yet. And he told us he wrote back, and holding the class in thrall, he produced an envelope bearing a House of Lords seal and proceeded to read out the reply, which was something to the effect of, "Dear Professor McLauchlan, I quite agree with your views. However, we must proceed one step at a time." Right, said David, that's enough excitement for today. Class dismissed. Alas, however, it would seem that Lord Hoffman forgot his promise when he wrote his subsequent judgment in Chartbrook Holmes, and further communications between David and members of the United Kingdom Supreme Court, which, as you have learned, is quite a common occurrence, now tends to include the tender of a peppercorn. For some years, David and I have made it a practice to have lunch together once a month. And the entire purpose of that occasion is to have a companionable argument. He tries to persuade me, as he has tried to persuade you tonight, that the common law can do everything through contract interpretation. And I try to persuade him that the common law should stay in its lane and leave equity. Nicole's comment was redolent to this. Leave equity to deal with the cases on the margin through rectification so that third-party reliance is properly accounted for. That and litigation cost, which he tried to diffuse tonight, are at the heart of our difference. Well, tonight's thoughtful, highly intelligent lecture continues that argument in front of a very much larger audience. I have to admit he makes a very strong case. Ultimately, it was the one that carried the day in Bathurst in the Supreme Court, when it reversed my judgment in the Court of Appeal. But a vote of thanks is not a right of reply, let alone to my colleagues. In truth, the argument that Dave and I have maintained is simply one between a common lawyer by conviction and an equity lawyer by conviction. Like all good arguments between men of a certain age, like where the best river is to fish or which pool is the better one, it's essentially pointless. Because we agree on the remedy in 99 out of 100 cases. We catch the same fish, it's just our casting method is different. The madness is all about the method. Well, as I said, tonight has likely been David's last public lecture in a 54-year career as a public academic, but happily it is not quite his last word. For many of us, despite his utterly remarkable record, there had always seemed to be one thing, just one little thing missing. 2 years ago, at lunch at McLauchlan, I said to David that it would be a great shame if he retired without at least collecting and updating in a book his contract scholarship that had been published in so many journals around the world. He seemed unconvinced, as he always is, by my arguments. And then a few lunches later, he said he'd had a better idea. Well, of course he had. And so it is that later this year, we will see the first volume of a new textbook on contract law written by Professor McLauchlan and published by Thomson Reuters. It will take a dialogical approach to contract law, taking the form of lectures on specific subjects and cases, complete with an imagined dialogue between a law professor who seems to me brilliant but oddly familiar, and a law student, also in most cases brilliant. Now, a legal text based on lectures is not a new idea, but typically David has found a way to do it both differently and better. There's something that more than 15,000 lawyers look forward to, and so therefore I imagine it will sell quite well. It also will be a textbook in contract that tells you that what the parties meant is what the contract means. Now it is time to extend some thanks. First, heartfelt thanks to the Ivor Richardson Lecture for 2024, the legendary Professor McLauchlan for his outstanding, thought-provoking paper that drew several threads of contract law together and showed us a new garment made in New Zealand, an intellectually consistent approach to contract formation and construction. Secondly, I think we should acknowledge the person who has given David the greatest support over his 54 years of teaching and will have been so influential in keeping him here at Victoria those many years. And I'm referring, of course, to David's wife and partner of 53 years, Pauline McLauchlan. Who did not want any fuss made of it. But there we are. David's been let down by Lord Hoffman, and I've always been let down by me. I'd like to thank collectively those responsible for the holding of tonight's lecture. The lecture was named for Sir Ivor Richardson, as Graham noted. His clear-sighted and context-rich influence over generations of New Zealand lawyers and academics remain profound. On my desk, I keep a small framed photograph of Ivor, which has the letters WWSIRD beneath it. It was produced by my first clerk, who remembered something I'd said at my swearing in as a judge. I'd asked myself the question, and I always do, what would Sir Ivor Richardson do? Secondly, the Suzanne and Michael Boren Foundation, who have generously sponsored the organisation costs of this lecture for second year. We're very grateful to them, represented tonight by Justice David Goddard, of course, another of David's students. Thirdly, Minter Ellis and Rudd Watts, as you've heard, are co-sponsors this year, marking the fact that Ivor was a revered partner of their firm, Watson Patterson, from 1973 to 77, between deanship of this law school and his appointment to the bench. Victoria University has taken up the organisation of this lecture, and we're very grateful to Victoria Beckett and her team, especially Jess Gray. And finally, and then you can go and enjoy some refreshments, can I thank the fellow members of the Ivor Richardson Lecture Organising Committee, Graham Austin, David Collins, Darlene and Matthew Palmer. Please thank them all with me. Good night and good luck.